Okay, abusunya latest update on Torkornoo. The actions are taken is yemfa and stop the appointment and the vetting of a Baffoe Bonnie. Abusunya CCR High Court and make it Torkornoo useless. HSA Omo approve a year. Paul Baffoe Bonnie ne appointments and then the vet na Babekoso our parliament as a former Chief Justice Torkornoo abusunya omo making the useless amamena de asem no de obia bonechi erefa ho a enya asem keto akran panyimfo atena asem me yanko na yenkonkotie ensem bia ekoso unsubscribe ya subscribe like na share ma afofron so ensa into me enkabia ha Ghana Politics Avenue. So and don't forget to click on the notification bell so na any updates be drop bia no so onsa ebe to me akabi medamase
what her sought to take to court. Why do I say this? For every public office or an independent public office which she headed, there's something called the dignity and sanctity of the office, which the holder must respect. And I want to believe that she respects that. She's been a judge before, and we know how judges could be upset when a ridiculous bucket list or when lawyers come before them and they are viewed as trolling, hoping that something sticks. It's exactly what she's doing. Will she not be mad at any lawyer who tries to do what she's doing today? So that questions the sort of Chief Justice she was and how she viewed things from a legal lens. That said, this decision taken, the president did not do it arbitrarily, right? It went through a process to the Council of State. He was binded by the decision of the Council of State to be taken. It was not a green letter that emanated from the Jubilee House or the Flagstaff House firing the Chief Justice. Due process was followed, with the president taking the decision. I mean, there are people who even think that the president is very lenient on this case. That said, I commend him for having exhausted every avenue. Whilst this was going, she exhausted not only internal judicial landscape in trying to save herself, she went all the way internationally. How many people have the luxury to do this? Or how many had the luxury 8 years ago to do this within the confines of any government? So you look at it all and then you wonder where she's going with all this. That said, no one is even going after her. Whilst the process was ongoing, she enjoyed all her privileges to the extent that she still went with close protection to hold a press conference at the Palms, formerly known as the Holiday Inn. That tells how accommodating the government is. But that doesn't tell her to be outplaying her hand in the way she's doing for, we should respect the institutions we once had. For me, if her review, Nana talked about constitutional issues here. If we feel that an article, it's a bit wobbly and we want to fix it, that doesn't negate the decision that was taken in reference to her going away. We can look at that. If she feels that, okay, you've taken me off, but I want to go home with my entitlement. Fair enough. That's something we can look at. But this ridiculous bucket list, I'm really wondering where she's headed with all of this.
You have repeated ridiculous bucket list.
Mention the issue. You can reiterate the issues.
Bucket list means that...
No, bucket list, yeah?
Okay. Would mean that it doesn't fulfill any of the grounds.
She went to the courts with.
Okay, I now get that.
Yeah, I feel it's
bucket list.
Yeah, bucket list. It's very ridiculous.
Right. And again, you have repeated it, so many times. Oliver sitting here.
Yes.
Personal question.
Yes.
Will you take legal advice from him?
Oliver is a qualified lawyer.
Will you take legal advice from him?
If he's a qualified lawyer, I'll take legal advice from him.
It's not if, he is.
Yes, so but I have to make it clear that if he is, okay, he is legal. So, I would. But that doesn't mean it's binding on me.
I'm asking you.
I will shop. That will include Oliver.
Essentially, I'm saying,
yes.
Do you respect his legal brains and how he's able to do his thing?
Well, I'm an intellectual.
Right.
Regardless of his legal brain, I respect his intellect, and I'm happy to engage with it.
You don't think you should be taking a cue from him? You say this is ridiculous. Oliver will not say this is ridiculous.
No, I would.
You heard him.
Yeah.
You say this is a bucket list.
Yes.
And you repeat and derogate.
No, something. When I say a ridiculous bucket list, I think probably you have to understand the lens with which I'm coming from. She is a former Chief Justice.
Yes.
And some of the things she's requesting, Oliver himself here, whose mind you are seeking that I respect.
Your commentary.
Yeah.
Is in the line, and I cannot dictate what you say.
Yes.
But your commentary is in the line of comments we have heard, like yesterday.
Yeah.
someone sits in their office and in their home.
Yeah.
The lawyer involved, you see, it's no mean lawyer.
Yeah.
Okay, and he would have worked with the client, the Chief Justice, who has about 3 decades, practice of the law as a judge also, and they put together in excess of 200 pages of documentation, and they file in the courtroom. The media goes to see it, then they bring it, they tell the public about it. They call lawyers who perhaps may not have read 1 page of the document, and they give sweeping, general, commentary that impugns the competence and the integrity of both the lawyer and the former Chief Justice. Do you think that is a fair comment to call this
to make it fair? Yeah, this is a very big platform. To make it fair, let us enumerate for your listeners. You mentioned some of the issues she went to court for. That's why I'm not saying that they are ridiculous in blanket terms. For who she is, rising through the ranks to become Chief Justice. And I mentioned to you that even judges, when you go before them with a list of certain reliefs that you are seeking, and some of them seem very frivolous, they could be mad at you. And you agree with me, you are a practicing lawyer. And I'm saying that in her courts, when she was practicing, if such a list came before her, how would she treat it? And I find some of the things she's asking for ridiculous. For us to have a stalemate and not have a Chief Justice, is that not ridiculous? Tell me if it's not. So if I tag that as a ridiculous bucket list, that's where I see it from that lens. Because the country cannot come to a grant because someone wants to be Chief Justice and no one else should be Chief Justice. That is the lens from which I'm coming from.
She says she's been wrongly removed.
Yes, so we can look at it.
And the removal process, while it was going on,
so now
there are court processes seeking to impeach the process.
So,
and eventually,
and all of those processes went smoothless without any intervention of the state, to the extent that she went international, she went external. Now, let's look at it within the confines of your 4 issues. Illegality, was it illegal? Tick. No.
You say no.
Yes, I mean, with the public, you are a lawyer. Was it illegal in your opinion?
Was the process?
Well, it was a process. Was it illegal? You are a lawyer now, so I'm asking now, take legal advice from you. Was it illegal?
No, the question now, about illegality,
right?
Not that the process put in place to remove her is illegal, but that breach of law happened
within. Yeah, that is nobody saying it's illegal. We understand it. We understand it within that confines. So within that confines, is it illegal, or could that illegality be determined? Right? Does the Wensbury principle apply here? Was there procedural impropriety?
Okay, that's
right. The legitimate expiation of her is something we can look at. So we are looking at it from these confines, and we are ticking the boxes. Tick, tick, tick. So no one is looking at it from a vacuum.
Okay.
And we are constrained by law.
Thank you. Thank you. Yes, come on.
Well, something very interesting stance here, but let me look at it from a historical background. Samson, you are lawyers, and of course, we are trying to see how we can trace your footsteps. I was told of a case, a popular case in the 60s.
You see, before you start, you see this thing you guys do? You are a lawyer, I'm not a lawyer. No, wait on.
But that's true. And that's a statement of...
I think that there are a number of things which we can all concede, which is that we have never, in this manner, removed a Chief Justice before. And so for me, the issues that she's bringing up are interesting for our democracy, both in terms of constitutional and administrative law. And we have to at least acknowledge the utility of the process that we are going to. What she had shown is that she has decided not to walk away quietly. And that, for me, at least that's commendable, that a person who believes that their rights have been aggrieved would have a framework for where they are challenging that. Now, that said, I am hoping that the way in which we treat this, that we treat it with a lot more sober reflection than outright dismissiveness. That the issues she's going to be bringing up, that her colleagues in the judiciary are not only going to look at the executive posture and say that, well, the executive has already moved on with a new candidate, and for which reason we must ensure that that status quo remains. So she has to get a fair hearing, and I'm hoping that the judiciary is able to afford her that. Administratively, there are questions, for instance, about whether significant findings of fact that were made by the command committee can themselves be disturbed by another body, or whether or not that process cannot be challenged in some regard. That's something that will be interesting to find out. I am not certain, in terms of my understanding of how we have done these things previously, whether or not the going forward with the appointment of a new person and the process of vetting the person can be stopped. I say this because, first of all, the judiciary must continue to function. And if she is found to have been wrongly removed, there's nothing stopping us from bringing her back in terms of how our law functions. So the mere fact that somebody has been vetted or whatever is done, if a former Chief Justice has not been rightly removed, there's nothing which would say, well, there's a fait accompli, and for which reason we can't bring her back. So that's my thinking. And so I don't particularly understand that relief, but I still believe that some of the questions she's raising, I do hope that, when proved, or if proved, that I'll be interested to see what the court ultimately decides on this. Not only in terms of what is before the High Court, but also some of the issues before the Supreme Court that we are aware of. And we know.
You said you are not sure, but what are you thinking? That the Article 146 process, when it's complete, it is subject to a judicial review by a High Court?
So, in terms of administrative law, it's a quasi-judicial body or judicial body, as you think about it. Its decisions are consistently challengeable. Whether or not it followed proper procedure, whether in terms of administrative justice, it offered her the hearing that she deserved, the manner in which it was offered was consistent with law. These are all issues that are challengeable, okay? And in connection with that, she's entitled, for instance, and we have said this previously, she's entitled to the report, she's entitled to be able to assess the reasoning, she's entitled to be able to see the facts that were sifted, to see whether or not those facts bear themselves out. All that process, I think, she's entitled to it. Myself, at this point, I think it's a bit premature even for me personally to be able to say that, all of the claims that she's raising are not valid. And even when some of their claims are valid, whether or not they would lead naturally to the invalidation of the work of the committee are also issues that, deserve question. But I think somehow she has not lost faith in the judiciary, and I think perhaps that if there's any value to commend here, that's it, I would say.
Interesting. But I've heard you, often refer to the very first time that Article 146 was used under this dispensation, the 1992 Constitution. And that was in respect of Dr. Emmanuel Jacob Emmanuel Oppong, who was removed as a deputy chairperson of the National Commission for Civic Education on the 28th of August 1999. And when he decided to challenge it, he went straight to the Supreme Court and he lost.
Yeah.
Because I have heard you refer to it, what do you say?
Well,
which is the better forum? Perhaps?
So the funny thing about, that decision itself, I'm not even certain that the Supreme Court sufficiently understood the law. Because the Supreme Court had assumed that the Article 146 committee is a commission of inquiry, and for which its reports must await a period, there must be a white paper, and then, you challenge it in the way in which a report of the commission of inquiry is done. But now we understand, we have better clarity.
Let's educate the people.
Yeah.
A commission of inquiry's reports, when they do a finding and they finish, it becomes
it's like a judgment of the
High Court.
Yes.
And it's appealable to the Court of Appeal.
Absolutely.
Within 6 months.
Within 6 months.
Okay.
So that's what the Constitution establishes for that framework. There's a real question as to whether or not the Article 146 committee is equivalent to a commission of inquiry. I don't necessarily hold that view, and I think that subsequent bodies haven't. In fact, Supreme Court decisions also suggest, like for instance, they don't have the power of contempt and things like that, suggesting that we are trying to create a distinction between the 146 committee and also commissions of inquiry. So that route necessarily would not be the most appropriate route. So even though there's a Supreme Court decision on it, I think that, if you go back and review it, that will have a different opinion on it. So I think the appropriate forum in this case is the High Court, I believe.
Okay.
Because the High Court, and they're invoking the High Court supervisory jurisdiction.
All right.
So I think that's fair in terms of where they've gone.
Okay. Before I come to Prof, let me go to Nana. And Nana Yasapong, already we have heard people who have been very dismissive. I've listened to Professor, I said Professor. We all have come to say Professor because he was our director at the School of Law. Kweku and Sansari, we've heard Eduji, Tamaklo, and the rest of them, they completely just rubbish everything she has done and say, in the first place, you're in the wrong forum, so just get off. This is done and dusted. You can't make any headway. Kweku and Sansari says this is not a stool where you think it is dead, it is gone, it cannot be revived. From where you sit, what do you say?
Thank you very much. Good morning to my colleagues. As an interim new Deputy General Secretary, I would have to say good morning to my party members and to thank God for their lives. Some traveled all the way from the various regions to witness the unveiling of the.
We'll talk about the UP Plus soon. You know, it's a second important subject.
And my brother Kamal is here, so. Thompson, it's an interesting discussion, and I think that Madame Torkornoo has done her best, and just as Oliver had stated, the issues she's raising, though cannot be substantiated or do not have the legal legs to stand on, I think that it would be good for our history. I think to be good for our, you have something you call legal jurisprudence and for further studies. And so, of course, in as much as I sit here not a legal brain, but I think that there is nothing in there that can be substantiated. But on the other hand, She says,
yes. She says, you have removed me on travel expense, ground one. That travel expense, I didn't get up, go put my hand in our account and pick money. There was Judicial Secretary, there was Finance, Department of the Judicial, Service. All of them came together and determined that I was entitled to this money, and they gave it to me. Number two, you say, I have transferred judges, or I have transferred people. That is a power I have as the head of the judiciary to transfer people. So what are you talking about? Okay? You say...
Power given you should be used right. There are procedures. On the other hand, something, you are a lawyer. You understand this. You are not a thief. I am the thief. I steal. I sell to you, I dash you, you take it. What are you? Yes, she was not responsible to have gone into the coffers to take the money. But can that issue be lined as an act of corruption or an abuse of office? Do you think in any case that the accountant, whosoever was responsible, could have turned down any instruction by the Chief Justice? Not at all. Not in our jurisdiction. You understand me? But the interesting aspect of it is that this is the first time such a petition has traveled the full hall. You understand? And so we are seeing what we are seeing because we are experiencing it for the first time. In any subsequent event, I do not think that we would have the luxury of our executive time to be discussing it because we would have seen it before. And so I understand the, as Antifobe said, the dummy that is being played. But one thing she should understand is that I agree with Sansari. It is not a royal stool where she would have to sit on it forever. What has happened has happened. Yes, she would have to go. She has gone. She has to go in peace. And I agree also with Sansari when he said that you can do this in another form, in another way. And so that probably the implementers of whatever recommendation that was on the report would agree and probably make you retire peacefully and for lack of a better expression, diligently, and so that you would go home with whatever that you would have to go home with. And then we can move. The judicial service cannot come to a halt because the Chief Justice is taking us to court. No. If I were the president by now, there would be a new Chief Justice in place. I think that we need to move on as a nation. And let us also agree that if we have been able to pin holes in Article 146 Then if we are calling for an amendment, we call for an amendment. Let us have a national dialogue on it. Let us discuss if we would have to make it more rigid, then we'll make it more rigid. And then we look at the procedures that are involved. But as it stands, no single clause in that article was breached.
Okay.
And I had stated before, even if any was ever breached, she was the one that breached one when she went to hold a press conference.
Okay. Look, when we go to court on a judicial review, we have three to four main grounds for which we go for a judicial review. And judicial review is for the High Court to supervise, mostly the High Court, but sometimes it can go beyond the High Court, to supervise the realm, so that if an administrative body takes a decision which is wrong, then we'll go to the High Court to test if the decision is actually wrong or it can stand the test of the law. So when we are going, we go over that there's an illegality.
Those are the thresholds. Right?
Yes.
Okay, Abusua Wene and Sama Ekoso, our political highway. So a year former Chief Justice Torkornoo and I see the action now take here, a year courts amana useless. I almost say, Mammy, yan so dear, oh, as a oko, na okope obebida. You better must say, some of Japan cocoa and some way at my aha, Ghana politics avenue, so, Madam Massey.